So today, the United States Supreme Court just issued an absolute blockbuster 6-3 ruling, and this is massive and it's a huge victory for the Second Amendment. Today, we got the ruling in the critical concealed carry restriction case that we've been following, which is Wolford versus Lopez. The majority of the Supreme Court in this opinion dismantled an aggressive, coordinated gun control scheme that was specifically designed by the state of Hawaii and other states to essentially circumvent and disobey the prior Bruin ruling that was issued by the Supreme Court. Now, to really understand why this 6-3 ruling is such a massive deal, we have to look at how these anti-gun states reacted to the Supreme Court when they struck down New York's concealed carry restrictions, which happened about 4 years ago. Bruin established a clear rule that the Second Amendment protects an individual's right to carry a handgun outside of the home for self-defense. Now, these restrictions the Supreme Court found on the Second Amendment essentially must be justified by a state or the government using the text, history, and tradition of the Second Amendment, and they have to show analogs or other types of evidence that show that they can put in place these type of restrictions. Essentially, Bruin found that at step 2 of the analysis, the burden shifts to the government to justify their restrictions. Now, knowing that they can no longer completely deny permits outright, states like Hawaii, California, and New York decided to make those permits essentially useless even if you got them. They did this by attempting to completely flip a century-old common law rule regarding private property on its head. Historically, if a business is open to the general public, something like a grocery store, a gas station, or a restaurant, essentially law-abiding citizens have always had an implied license to enter unless the owner explicitly posts a sign stating otherwise. Hawaii and other states flipped that on its head. They passed a sweeping statute making it an automatic crime to enter any private property that is open to the public while you're armed, while you have a concealed carry on you, even if you have a permit, unless that property owner gives you express permission to do so by posting a sign or maybe even giving you verbal permission. But now the Supreme Court, in this new 6-3 ruling that came today, struck down that law and reiterated how the Second Amendment analysis must be performed. Now, before we break down what happened in this ruling and the implications of this going forward, if you like this video and you want to support the channel, one of the best ways to do that is simply by liking, commenting, and subscribing, and also make sure you turn on all notifications to ensure that you get these videos when I release them. And also, since we're talking about self-defense and your right to concealed carry, I want to mention one of the main partners and supporters of this channel, which is Attorneys on Retainer. If you are a concealed carry holder, which is again relevant for this video, check out AOR. In my opinion, they have the best legal protection on the market for you if you conceal carry. They're backed by an actual law firm that's been doing self-defense work for years, and they don't have a bunch of exclusions or opt-outs like other companies do. So again, check out AOR using the link down below. And if you use my code ARMSCHOLAR for a limited time, you can get $50 off of your individual sign-up fee or $25 off of the family sign-up fee. Now, in today's ruling, in the majority opinion, which was authored by Justice Alito, he laid out exactly how absurd and dangerous this law is. He walked through a hypothetical day in the life of an ordinary citizen trying to exercise her constitutional rights even though she has a concealed carry permit. Now, under Hawaii's framework, if she goes to work, stops to get some gas, grabs lunch or dinner, drops off clothes at a dry cleaner's, or picks up groceries on her way home, she could become a criminal about 6 times over that single day just because she has a permit and goes into some of these locations. He pointed out that the state knew exactly what they were doing with this law. They essentially know that most business owners are not going to post these signs saying, yes, you can conceal carry at this location. And essentially that forces, individuals here, not just in the state of Hawaii, but other states, to essentially either become a felon, to violate the law, or simply just not conceal carry at all. He stated that Hawaii successfully created a stealth comprehensive ban on public carry, turning ordinary law-abiding citizens into instant felons the second that they step foot out into the public. But today, the Supreme Court drew a definitive line in the sand. Now, writing for the majority, Justice Alito systematically dismantled Hawaii's legal defenses and arguments at every stage using the Bruin framework. First, Hawaii tried to claim that the Second Amendment simply does not apply to private property that is open to the public. Justice Alito shut that down immediately, confirming that carrying a handgun for self-defense is precisely the type of arms-bearing conduct that is protected by the Second Amendment. He pointed out that when a state manipulates property laws to restrict that conduct, it is a clear violation of individual liberties and a violation of the Second Amendment. Now, the real embarrassment for the state of Hawaii really came during the historical analysis under Bruin. Now, under the Supreme Court's established precedent, if a state wants to regulate a constitutional right, it has to prove that its law aligns with the historical tradition of this nation. Hawaii's legal team showed up to the court with two primary historical justifications, and both were utterly just completely rejected and struck down by the majority. First, they cited 18th century anti-poaching laws. They actually tried to argue that because early colonial legislators restricted people from hunting deer on certain farms, essentially modern governments could also have the authority to ban a citizen from carrying a concealed firearm into certain stores. Justice Alito completely dismissed that argument, pointing out that the legal gap between preventing poaching on private land and implementing a sweeping statewide concealed carry ban is far too wide to actually bridge. He said that they're not even close, and therefore he rejected that argument. But their second historical defense was even worse. Hawaii heavily relied on an 1865 Louisiana statute to prove that this law was valid. Now, Justice Alito and the majority exposed this on the national stage, explicitly pointing out that this was part of the black codes that were passed post-Civil War. These were discriminatory laws that were passed by defeated Confederate states, specifically to disarm newly freed individuals. Alito delivered an absolute blow to that type of state legal argument, and really this team and the state saying, essentially, why are you using these types of laws to justify this current law that you put in place in Hawaii? He stated that against this history, Hawaii's claim that this tainted artifact illuminates the original understanding of the right to keep and bear arms cannot be taken seriously. So essentially he said, there is no way that we're going to take this argument serious because you're using these, discriminatory laws to try to justify this concealed carry ban. Now, in another critical section, the majority opinion embarrassed the lower court's attempt to justify this restriction by pointing to the tradition of Hawaii itself and the claimed spirit of aloha. Alito stated in his opinion that, as the plurality explained in McDonald, the Second Amendment has the same meaning in all parts of the United States. It cannot give way to the spirit of aloha in Hawaii any more than it can yield to the spirit of the Big Apple, which he references there Bruin, or the spirit of the Windy City, which is there he's referencing the McDonald case. Merely local attitudes can neither shrink nor inflate the meaning of the fundamental Bill of Rights guarantees that apply to the states through the 14th Amendment. To me, this is a very interesting line because not only does it reject Hawaii's whole spirit of aloha rationale, but it also calls into question how you have outlier states like California and New York that deviate from every other state, majority of the states, and try to ban things like rifles and magazines. So I have no doubt that this line also will pop up in a lot of the current 2A cases that are moving through the courts and potentially a lot of other future 2A cases as well. Now, of course, there were dissents that were written in this case. You had the liberal block of justices, where you had Justice Jackson, who wrote a dissent and was joined as well in that dissent. Now, her dissent essentially is her pointing out that, they did not actually use the Bruin analysis, that they changed the Bruin analysis, and she also tries to frame this whole issue as a property rights issue, not a 2A issue. In the dissent, Jackson argued that this was merely a routine property rights issue rather than anything dealing with the Second Amendment. She also claimed repeatedly in the dissent that majority here of the court was changing the Bruin analysis, but also if you've read any of her prior 2A dissents, she talks about how the Bruin analysis is incorrect and it needs to be done away with. Now, in response to this, really, you had the majority and also some of the concurrences reject this whole property rights argument. Justice Barrett, in her concurrence, kind of called out this weak attempt to justify this Hawaii law as simply a property rights issue. In that concurrence, Justice Barrett stated that property laws, no less than other laws, are subject to the constitutional limits. So when a property law restricts the bearing of arms, the state must prove that the law abides by the limits of the Second Amendment. So in this ruling, the Supreme Court struck down this catch-all property ban in their 6-3 ruling. Therefore, they reversed the Ninth Circuit's ruling in this Wolford case and remanded the case back down to the Ninth Circuit for reconsideration in light of this new ruling. This is an enormous precedent because it doesn't just stop Hawaii, it effectively strips the legal foundation out from other identical kind of default ban laws that have been passed in other states like California, New York, Maryland, and New Jersey. This ruling also did, once again, a thorough walkthrough of how the two-way analysis must be performed under Bruin, and this is no doubt going to impact other two-way cases moving forward. So let me know your thoughts down below on this big two-way decision that came today. Let me know what you think about this opinion down below. Also, let me know what your favorite part of the decision was. If you like this video and you'd like to support the channel, one of the best ways to do that is simply by liking, commenting, and subscribing. And make sure you turn on all notifications to ensure you never miss these updates. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.